instancia estaría bien, ¿no?
Vale, perfecto.
Excelente. Bueno, muy amable, señorita Buitrago, y seguiremos acá. Cualquier duda que tengan, por favor, estamos a la orden.
Vale, gracias. Entonces, estamos esperando el resto de nuestros compañeros y ya.
Perfecto, perfecto.
Gracias.
Muy amable. Buen día.
Buen día.
nosotros escucharla aquí en sala.
Hola, buenos días, ¿cómo están? Mi nombre es Sofía López de la Corporación Justicia y Dignidad.
Súper. Sí, se oye muy
Perfecto.
bien. Muchísimas gracias. Ya puede apagar su cámara y su micrófono y esperar a que comience la audiencia. Señor Valencia, buenos días. Si es tan amable de habilitar su cámara. Señor Valencia, si es tan amable de habilitar su cámara y su micrófono. No lo vemos ni lo escuchamos. Mira. Buenos días, señor Valencia. Aún no lo vemos ni lo escuchamos. Si quiere volver a salir y entrar, quizás es su conexión de internet, que está muy débil. Señor Jorge Darío, si es tan amable de habilitar su cámara y su micrófono para probar su audio y su vídeo. Eh, Señor Darío, no lo vemos ni lo escuchamos. Eh, si necesita alguna ayuda, por favor déjeme saber en el chat del aplicativo. Si son tan amables de escribir. Ahí lo vemos, señor Darío. No lo escuchamos aún, señor Darío. Señor Darío, no lo escuchamos. Lo vemos, pero no lo escuchamos. Si es tan amable de hablar.
Buenos días, saludarlos. ¿Me escuchan? ¿Me
Si
escuchan?
puede volver a hablar, por favor.
¿Me escuchan?
No, yo creo que no está tomando su... diga algo más, por favor, cuente hasta 5 para ver si lo escuchamos aquí en sala.
Buenos días, 1, 2, 3, 4, 5.
Se escucha pero un poco bajo, quizás tiene que acercar un poco más su micrófono.
Buenos días, 1, 2, 3, 4, 5.
¿Aló? Así
¿Sí me
está
escuchan?
mejor. Hay que acercarse un poquito más al micrófono.
Buenos días, 1, 2, 3, 4, 5.
Sí, ahí estaría bien. Muchísimas gracias. Puede
Bueno,
quedarse con su cámara apagada y su micrófono hasta tanto sea su turno. Muchas gracias.
bueno.
A usted.
On hearing number 3 of the 189th session of the ICHR on forced recruitment of indigenous children and adolescents in the armed conflict of Cauca Department. Welcome, civil society who are connected online or joining us online remotely. Good morning to every one of you. Good morning, a distinguished state of Colombia, the representatives. Thank you for attending. And I welcome expert Yvette Rivero, is the representative in Colombia of the Office of the High Commissioner for Human Rights of the United Nations. I am joined here at the table by Commissioner Bochak and Commissioner Christopher Bulcan, Executive Secretary Tanya Renaud, and the Assistant Executive Secretary Claudia Pulido, and the Rapporteur Palomino of the Redesca is about to join us remotely. Fine. Additionally, this is an important occasion because we must remember that the Inter-American Commission of Human Rights is celebrating its 65th anniversary of work committed to the defense and promotion of human rights. Thanks to the interests and common interests of states and consensus of states and societies to make the American Convention and the Inter-American Democratic Charter a living document. Since that time, hundreds of professionals have come through this institution, and thousands of individuals and groups and peoples have resorted to the Commission in search of protection, justice, and reparation. We held the 65th anniversary with more than 100 in-local visits with the corresponding reports, more than 1,000 precautionary measures granted, more than 750 merits reports, 220 friendly settlements have been approved, and 377 cases brought before the Inter-American Court of Human Rights. All of this has been victim-centered, at the heart of our work and our highest priority to make sure that this hearing is inclusive. We request everyone taking part herein that to introduce themselves when they take the floor, say your name, your position, and the organization or institution you belong to. Subsequently, each time you take the floor, we would be grateful for you to say your name again at first. And in this way, those with visual disability will be able to realize who's speaking. Likewise, we remind you that these hearings have available closed captioning on the screen. You can activate it directly on your devices or equipment and select the size of to view. And also, for those who are following us through our channels, ICHR channels can do so as well, can use closed captioning. Before giving the floor to civil society, I'm just going to explain how much time there is. Civil society will be speaking for 20 minutes. Then the state will speak for another 20 minutes. We will be keeping time. The UN expert will have 7 minutes to speak. And then the ICHR will, among all of us, we will have questions and comments, 20 minutes to do so. We will wrap up with 10 minutes of comments from civil society, 10 minutes from comments from the state, and then the closing. Fine. So I have now, I'm going to say what the purpose of this hearing is, and then I will give the floor to its purpose is to present the seriousness of forced recruitment of indigenous children and adolescents in the Department of El Cauca, to call on the government to implement a humanitarian public policy of prevention of forced recruitment. So civil society is up. Good morning. You have the floor. Good morning, Honorable Commission. We are grateful for this important opportunity you've granted to the indigenous peoples of El Cauca to bring to your attention this important, dire issue. As you just said, the purpose of this hearing is to call on a public policy to be put in place to prevent this forced recruitment and the elimination of this scourge of these indigenous children and adolescents. And we bring forward a proposal for this purpose. We salute the presence of the representatives of the State of Colombia and the UN representative as well at this hearing. We will have Major Rosara Velasco, the highest advisor of CRIC, Major Darío Campo, advisor of CRIC, Germán Valencia of the Association of Municipal Governments, Alejandro Casomatin, also of CRIC, Antigüic Trago, coordinator of uprooting and for minors who have been recruited of CRIC, Maria Eugenia, who's the coordinator of the observatory, and myself, the director of the Corporation Justice and Dignity, legal advisor of the CRIC. At this hearing, we have specific requests for the State of Colombia for the Inter-American Commission we bring for you and the UN representative. To the Colombian state, firstly, we call formally on it that the issue of forced recruitment of minors be included in the dialogue, the agenda of the peace dialogue with the armed actors in Colombia. Secondly, we urge the Colombian state to assign a special delegate from the El Cauca Regional Council on the at the working group for the peace talks. This will ensure prior consultation with indigenous peoples of El Cauca in the peace processes and will promote as meaningful and representative participation of the affected indigenous communities. We demand immediate handing over indigenous minors to be handed over who have been forced recruited and to engage in humanitarian dialogue in these peace on these peace accords and to restore the rights of these children and to give them back to their communities. And fourth, we call on the recognition and financial and political support of the special indigenous jurisdiction to develop the self-determination of indigenous people. This is the only mechanism that we have in place at this time. It's fundamental for indigenous armed actor can demobilize and to facilitate the immediate handing over of minor indigenous children who have been forcibly recruited, and also in the program of re-entry and becoming rerouted to support this. Also, interdisciplinary body be created for the victims, and the office of the ombudsman and the Office of the Attorney General to include these children have been forcibly recruited and their family members they should be included on the registry of victims to ensure humanitarian aid to these people, emergency aid, and access to administration of justice to restore the right to truth, justice, and full reparation and non-repetition. 6, we request the State of Colombia to create specific programs of prevention of forced recruitment, both for armed actors as well as indigenous communities in the context of the agenda of the peace process. This should be formulated and pursuant to the use and practices of indigenous community and consulted with indigenous peoples that are the victims of this scourge. We call on the state to urgently to take military action in a joint fashion in consultation with indigenous peoples to dismantle the forced recruitment bodies in El Cauca that has begun since 2023 and has been brought to your attention by the Ombudsman Office. And this violates the rights of minor indigenous children and to ensure the well-being and the safety of these affected. Well, just 1 minute, could you speak a little slower, a bit slower, so that the interpreters can keep up?
You were.
Fine. I repeat the seventh measure. We request military action to be taken on an urgent basis and jointly between the state and the indigenous people to dismantle the forced recruitment center in El Cauca, which is in the municipality of Pluriville. This will be of great help to restrain the scourge of forced recruitment among these members of this community. And now, request to the Inter-American Commission of Human Rights. We request to make active all the precautionary measures that involved minor forcibly recruited children. And so the precautionary measures that are still in effect through the Inter-American system and that you're aware of, they have to be made active. But a working meeting should be convened with the state of Colombia to be able to lay out legal policy roadmaps that are effective to help these children and those who are beneficiaries of the Inter-American system. These precautionary measures are the MC 14110, where the minor Daniel Mostero Istu is the beneficiary of a precautionary measure. And at this time, in the second half of 2023, he was forcibly recruited right when he was in the midst of being returned to his homeland. And then the working meeting should take place MC 25511, this of the NASA plenum, which covers Pluribio, San Francisco, Cuacayvio, and Hambalo reservations, indigenous reservation. This should sit down with the state at a meeting to identify all of the minor children who have been forcibly recruited and organize handing over these juveniles. And in coordination with the state, the Foreign Ministry, and the UN Office of the High Commissioner who are coordinating the total peace process negotiations. And also we call on the Commission to engage in special file up of the precautionary measure of the corporation of the indigenous people of El Cauca and with regard to harassment and threats against the life and safety of the entire team of the corporation, this civil society organization, and with all the reporting, they have reported all these acts, and it should be followed up on. We also request a private meeting with the Inter-American Commission in April, when we can hand over a list of all the minors who have been forcibly recruited and for whom we want to advocate in a dialogue process for them to be handed over. Likewise, the ICHR, we're in this context, nationwide context, we're calling on you to look at the complaints we filed with the government with regard to the coup d'etat that's taking place, with regard to the Supreme Court and the current Office of the Attorney General is making it more difficult for the handing over of these children in the context of the peace dialogue. With the UN's intervention, since we have the presence of the UN representative, we want there to be ensured for CRIC and SIN, in the next Forum of Indigenous People, which will take place in New York in April. Next, my colleagues will continue providing information.
Ya.
Buenos días.
Good morning. My name is Germán Valencia. I'm from the Association of Municipal Governments of Northern El Cauca. We're part of the Regional Indigenous Council of El Cauca. Thank you very much for this opportunity, and thank you, ICHR, for opening up this possibility for us. And I'm going to read some notes where we express the need to strengthen these opportunities and how dire the situation is of these forced recruitment of these children, and the view and what's been done by the government or hasn't been done by the government thus far, and also a bit about the promotion of future opportunities which will enable us to report but also follow up on cases to improve the situation. Forced recruitment of indigenous children in northern Cauca. This constitutes a dire, gross human rights violation. In the case of indigenous people, a direct violation of their psychological and cultural and physical well-being. The armed force or illegal armed groups, or these minors are subjected to exploitation and abuse, depriving them of their fundamental right to a safe childhood. In addition to this phenomenon, it contributes significantly to the weakening and extermination of these indigenous peoples and their cultures. And it breaks with it tears them away from their traditions and practices. And the children are the seeds to be able to continue with our culture. And so with this violence, this puts an end to social cohesion, and it will create a rupture and disrupt our culture. And so we are decrying this situation. We've done so before international bodies such as the UN and the Commission. We require intervention. You play an important part in the defense and promotion of the rights of the indigenous communities. And this exposes these violations that have been perpetrated and promote concrete measures to prevent this forced recruitment of these children and protect these minor children who are affected, and ensure full enforcement of the instruments and the principle of self-determination and indigenous justice. We raise the profile of these dire or gross human rights violations. These communities should be recognized, and we should strengthen their self-government and self-justice systems of these indigenous people, as well as implementing specific measures of protection adapted to their cultural situation. This is the roadmap to move forward and build a future where the rights of children, indigenous children, that are respected, where their communities can flourish in conditions of peace, justice, and dignity. It's so troublesome and concerning that since March of 2023, the Ombudsman's Office has brought attention to the center of forced recruitment in our area. And these people are beneficiaries of precautionary measures from the ICHR, but nothing has been done to dismantle this center. The competent authorities have lacked diligence in protecting the human rights of these indigenous children, and there's been a lack of compliance with international obligations that have been undertaken by the state when it comes to the protection of the rights of these peoples and this forced recruitment. More alarming is that the precautionary measures granted by the Commission have not led to any tangible results, nor has there been provided relevant information about the decisions that have been taken to address the situation. The lack of transparency in this regard imperils the lives of these minors who are affected. It's absolutely determined to safeguard life for these minors and the survival of our peoples, and there should be specific actions taken that are effective in protecting these children. And to dismantle this forced recruitment center and ensure and protect the human rights of the children in compliance with the precautionary measures. And these are the notes we've taken for you to become aware of these situations. And based on this, so you can see how dire the situation we're experiencing in northern El Cauca and the scourge of the forced recruitment of indigenous children. Thank you very much.
Muy bien.
Fine. You still have 4 more minutes left. If you are not going to use them, we can now give the floor to the state, who has 20 minutes.
Buenos días para todos, para todas. El Estado.
Greetings and good morning to all of you. The Colombian state is bidding everyone here, the distinguished members of this distinguished commission of human rights, and indeed to all the representatives of civil society, and express our gratitude for this opportunity to move forward in this constructive and far-reaching dialogue on the situation of the forced recruitment of indigenous children in the El Cauca department of my country. Lourdes Castro Garcia, the President's Counselor for Human Rights and also specialist in humanitarian international law, the representative of the Colombian Institute for the Family, Eliana Cáceres Cardenas, and representative of the Ministry of Defense, Garcia Correa, the representative of the Justice Department of Colombia. All of them shall, of course, contribute to, as needed, any information needed to provide an overview of the multiple actions and measures that the Colombian state has been deploying in response to the matter that we are addressing today. Colombia, as you may know, has always upheld the respect for human rights. Colombia is well aware that children have capacities, talents, and vulnerabilities that are inherent to their very childhood. Excuse me, says the chair, you're going a mile a minute, and it would be helpful to all of us who listen to you and who are interpreting for you if you would be kind enough to read at a normal speed. Thank you. The state positively rejects the forced recruitment of children and adolescents, as well as all forms of ill treatment and abuse to which those children might be subjected. We are focused on ensuring that the human rights of all Colombian citizens of whatever age may be upheld and safeguarded now and for future generations. Democracy, we know, is the most important tool whereby we may guard against armed conflict and uphold justice, certainly rejecting any arbitrary form of justice that does not respect our rule of law. Thank you very much. As the next member of the delegation, we wish to address the question of national recruitment of children in all corners of the country, and particularly in the department of El Cauca. The illegal action of different armed groups are a grave peril to all those communities, not least the boys and girls of such communities, because they are very often recruited, subjected to sexual abuse and other forms of ill treatment. 84% of the townships of El Cauca are 45%, I should say, are in a very remote area, and many are in a critical situation. The national government, therefore, faces enormous challenges, and we have a means to do so, a plan We want to begin by recognizing that there is under-registration on the part of official records. They by no means reflect the reality on the ground. We need to change that. We want to strengthen the institutional framework whereby at the territorial level, at the local level, there is greater attention paid to the inherent and individual character of the national different entities and people who live there, and the use of systematic violence and sexual abuse of children must be denounced. And this Secretariat, through its technical wing, aims to do that. For 2024, we have a number of actions set forth. There will be a public policy that will seek to strengthen our links with indigenous peoples and our communication with them, beginning with the AWA group, in order that the CIPRUMA group can be better respected for their cultural and educational elements. We are also focused on raising awareness in society with regard to these very serious instances of child abuse in the context of this armed conflict. The International Day for Red Hands will make that more evident, and this is something we are carrying out with civil society. My group is launching a follow-up to the monitoring regarding the recruitment of children, boys, girls, and adolescents through the distribution of quarterly bulletins and a closer overview of the territorial situation. CIPRUNA, the acronym for my group, will be looking at the particular situation in the southeast of Colombia. These various elements of our comprehensive policy will be the subject of different round tables that will be held with armed groups that are outside of the law, that is, the armed groups that are outside the law at this moment. We have specific protocols to urge bilateral temporal ceasefires between the National Army and the ELN, which was first broached in Cuba and starting last February 5th decided the following: not using any child under 15 years of age in the armed conflict, this in consonance with international humanitarian law. That's the main element. The Colombian state is deeply committed to protect our boys, girls, and adolescents. And we recognize that these new efforts offer a potential that we had not had before for us to work more effectively towards total peace. Thank you. Thank you very much, and greetings to all of you. We in the Defense Group are well aware of the seriousness of this crime that the armed groups commit, adopting different strategies to recruit forcibly the young children, boys, girls, and adolescents, to recruit them forcibly and to retain them forcibly. The situation in El Cauca, which is the direct issue that we are addressing in this hearing, focuses on one of the most dramatic elements of this enormous problem, and the entire country is focused on how important it is that we better understand and fight against illicit recruitment. We have set forth a strategy that we believe reflects who we are and what we're doing in order to respond adequately to this enormous scourge. This includes the most recent sentence of 005 of 2024. The future generation, Generación Futuro, as it is known, focuses on better citizens coexistence for the period 2024-2026. We're also looking at what additional measures we can take to better protect life and the landholding of these lands where the criminal gangs are rife. We want to find out how we can best guard these children and offer them a safer environments so that the protection of their rights has a greater chance of obtaining. We've already mentioned SICURA, the acronym of the main group that is fighting for that. This is a problem that comes from a number of different sources: social exclusion, the fact of being marginalized, the lack of hope, and the dearth of avenues to look for a better life. This, we believe, can be best offset if we focus on the recruitment policy of the armed groups against the children. We need better to support those who are demobilized once they are. And that is something that the Ministry of Defense has put together from 2021 to 2023. Over that time, 600,000 young children, of whom 601 national youngsters, and a number of them come from El Cauca. 286 have been demobilized and have been brought before a magistrate over that same period. 35 come from El Cauca and 37 from the indigenous peoples. All of them came into the armed groups when they were minors. Until they were 14, 118 were between 15 and 18. 218 were between 15 and 18. The national government in November of 2023 signed an agreement to address this issue and committed resolutely to protect the lives of those boys, girls, and adolescents within the context of the Ministry of Defense and the police, setting forth better strategies to tap their human talent and to spot forced recruitment where it exists. We take very good note of the petitions that are being put to us, and we shall move them on to the Inter-American Human Rights Commission in toto. Hello. I represent the Colombian Institute for the Family, and we greet you all. The Colombian government recognizes that forced recruitment of boys, girls, and adolescents is a flagrant violation of human rights. It is a tragedy, no less, and a cruel way of proceeding. And in our society, alas, despite all we've done, the scourge continues. The practice is rife, particularly in the countryside, among the indigenous and Afro-adolescent groups, thereby ensuring inequality and an ongoing vicious circle of cruelty and recruitment. The national government is committed, through the Colombian Institute for the Family, set forth 3 strategies that we believe can make the difference. We want to build a means whereby we can better fight recruitment, thereby guarding against their being ripped out of their families. It's important that there be direct involvement by the communities themselves, however. Without that, we won't go anywhere. We understand the social, economic, and emotional situations from which these boys, girls, and adolescents come, and what happens when they are ripped away from their own homes and family. It is precisely that ripping away and isolation of those children, as UNICEF has clearly pointed out, that those children are even more greatly violated. Children have been ripped away from their countries. In 2013 through 2022 was a program in which we set forth particularly what happens to those kids. 3 of the cases that have not been sufficiently focused upon come from ethnic groups. There were 10 percentage points in the participation of boys, girls in recruitment compared to the previous study. We have therefore set up a special program to fight the recruitment of these children. And from 1999 through 2023, the Institute, in fact, has focused on 7,500 and some children, 180 for 2021, 220 in 22, and another handful for 23. This will continue with the help of civil society in order to try to build back the lives of those children who have been so cruelly uprooted. In 2023, the Institute, along with the permanent group on indigenous welfare and a focus on indigenous women, worked to cobble up the agreement now known as Agreement 025, I should say, that focuses on guarding these children, boys, girls, and adolescents, from sexual abuse. Attention has been paid to the CRAC, that is the Amazonian population in the Colombian area, and AICO and a number of other indigenous groups in order to better spot risks and guard against their results. There are collective actions that have been taken to fight the forced recruitment of boys, girls, and adolescents in those indigenous groups where so many of the instances, in fact, arise. Together with UNICEF, we have set forth an institutional dialogue with the Indigenous Council of the Cauca Creek in order to plant the seeds against this forced recruitment and fight that ongoing recruitment of youngsters in El Cauca. This, we believe, is the way whereby we can better protect the cultural and civil rights of the people living there. It is important to understand how we can build better communities, what the strategy is. We have called it, for lack of any better term, fight for your dreams. And we hope that that will indeed map a road towards better opportunities, cultural, scientific, sports, and music opportunities will offer these kids a chance to move forward and to develop their talents and aspire to a happier life in peace. In 2023, as this strategy got off the ground, thousands of children throughout the country were helped, of whom 1,700 came from El Cauca. 1,700 of 48,000 some. Excuse me, you have 2 minutes and you're going a mile a minute. Thank you. For everyone's benefit. We'd like to underscore that for this government and for the Colombian Institute for the Family, it is key that we work hand in hand with the indigenous communities in their own territories, because we understand that is the best weapon against uprooting and forcible recruitment. Next, we believe that the recruitment of boys, girls, and adolescents and their use for the purposes of crime has to be an important element of our peace negotiations, and this has been recognized by all of the roundtables. Finally, we believe that in its various instances, this Inter-American Commission on Human Rights would do well to focus on this critical matter for us, thereby paving the road towards peace and a better life for all of our citizens that we denominate Colombia on the road to peace. Thank you. Commissioners, I'm Tatiana Garcia, Associate of the Fiscal Ministry. With regard to this hearing, the prosecution of our country, and this is set forth in our Constitution, wants very much to continue as active as it has been in setting forth our policy throughout the country, and certainly with regard to El Cauca, with a territorial and an ethnic focus particularly tailored to the indigenous peoples of that region. There is a special jurisdiction in the indigenous context. Mile a minute and too long. I'm sorry, but this is, well, it's a form of reply, but you know, it's part of our reply. Let's consider it that as we move forward. Why don't we just do that? Thank you. Let us now, says the chair, give the floor to Julieta de Rivero, who is with us, I believe, who represents Colombia on behalf of the High Commissioner of the United Nations for Human Rights. Are you online, representative of UNHCR? Now, we can't hear you. I'm afraid there is no sound. So sorry.
No, hay algún problema ahí.
There is a problem with your connection. We can't hear a word.
Señorita Juliet, si puede enviar.
Miss Juliet, could you send us a contact phone number so that we can communicate? Since we're not communicating by this means, your mic may not be properly configured. That may be the problem. It may not, in fact, plug into your equipment. Do you have earphones? That'd be a help so that we can, in fact, speak to you. Hope you have it. Do you hear me? Yay! We can now hear you with your earphones. I'm terribly sorry. Well, you have 7 minutes, says the chair. Let me begin by greeting the commissioners, the rapporteur for Colombia, the authorities of the state, and the authorities that represent the indigenous communities here, as well as the many, many representatives of civil society who are here with us in this important hearing. Back in 2018, our group has expressed great concern for the indigenous people's welfares in the Cauca. There has been a great rise in forced recruitment, homicides, particularly within the indigenous groups, the use of little boys and girls of indigenous origin, and aggressions toward the government itself, as well as certain systems of justice that are being disregarded, makes their lives and their entire system something that is greatly imperiled. The boys and girls of El Cauca have been increasingly imperiled, indeed, since 2018. We have documented innumerable groups, but this is but a handful of the enormous number of cases that are out there and that have not been actually pointed to or known by international groups because very few people have been able to list them. Grave violation of human rights against boys, girls, and adolescents in El Cauca have been listed since 2023. 24 victims were recruited and used and abused by state armed groups, which is certainly an uptick since 2022, when we had only documented, if you can say that, 9. There have been, in 2023, recruitments that come in El Cauca from ethnic groups, particularly the Nasa people. This has been documented by the office in El Cauca and represents 18% of the total that have been, in fact, noted in the country. The indigenous people of the north of El Cauca in 2023 included 123 cases of youngsters, boys and girls that are indigenous, that had been recruited and abused. the non-state armed groups exploit the extreme vulnerability of these youngsters. How can we possibly hope them to defend themselves because of their political and cultural situation? It's not a non-starter. And the means of recruitment, of course, is, as ever, lies and inducements, particularly vis-a-vis little girls, which, no surprise, end up sexually exploited. The victims who have the means of reporting have been subjected to extreme cruelty, punishment. Many others have been indeed assassinated and others gravely tortured while they were held hostage. 24 victims, as far as we know, were recovered thanks to the action of their families and the indigenous groups themselves. What does this tell us? What it tells us, surely, is that we need to bolster and respect their own governmental groups, their own civilian protection, to promote and to protect the well-being of their citizens and the members of that group. Boys, girls, and adolescents and their families continue to be the target of untold harassment and cruelty. In El Cauca, direct threats were issued against their particular groups or others, forcing them to get up and move while they could, which they sought to do. But that means that the institutional means by which we can move have not been effective. I'd like to point to a number of measures that we might do better. One, we call for the peace negotiations groups to include the rights of boys and girls as a priority in the ceasefire agreements, not as an afterthought, but as a priority coming in. The kids that are recruited by these groups are at stake. Article 24 of the agreement on the recruitment of these groups sets forth strict prohibition from recruiting children under 18 years of age for any means whatever. The state must take every means possible to ensure that that prohibition, in fact, is respected. The abuse, the recruitment, the ongoing sexual violation of this group, the group Cipruna works against this, needs to look at the financial and other means by which these children are lured into these different forms of recruitment. The use of indigenous boys and girls by the peoples themselves, let me say, must also be fought. There has to be better institutional work with the beneficiaries of existing precautionary measures, and let there be 3/16, the decree 3/16 of the Institutional Court be remembered and upheld, and not disregarded as is the case at present. All of this has to be rooted in community action, particularly the autonomous means by which the ethical people in the Cauca have been operating all along. Thank you.
Thank you very much, Ms. Ribeiro. Let us now move on to the remarks of the members of the Inter-American Commission. I'll give the floor at this time. Commissioner Bulkan. Bulkan has the floor right now.
And good morning, everyone. And I'd like to welcome the members of the delegation and to the representatives in Colombia. Thank you very much for all of the information presented. I have a couple of questions, both for the civil society and members of the state. And starting with civil society, you indicated in the beginning of your presentation that the Attorney General has been making it more difficult in this process of handing over and demobilization. Can you expand a bit on that and explain what you mean by this allegation that they're making it more difficult. As well, from the Association of, I think, Municipal Governments, it was said repeatedly that the precautionary measures granted haven't led to any tangible results. I'm wondering if you could perhaps briefly highlight some of the measures that you think are in dire need, perhaps, of attention that might have been, overlooked. For the state, thank you very much for all of the information that you've presented. Particularly, I'm curious about a number of things. Some of them might require detailed information, perhaps, but I think the Executive Secretary or the President might advise you as to how you can submit this in writing later. But I'm interested in starting with, there are a number of organizations or agencies of the state who are represented here. I'm curious as to whether there is some centralized agency of the state that might be coordinating these efforts in response, focusing specifically on this problem of forced recruitment. And if there is or is not, is there some means of tracking your successes? You've indicated that there are lots of measures being planned and I suppose ongoing. Is there some database or some process that's tracking your successes so far? And if so, can you share with us the figures of this demobilization and what's been, what's been achieved so far? In the course of your presentation as well, I heard the figure of, in terms of demobilization, some 600,000 children who were brought before the magistrate. Can you clarify for me, please, whether this process of bringing them before the magistrate, whether this is a penal process? Is it purely a penal process, a criminal process, or does it include, for this 600,000, if I heard correctly, whether this includes social rehabilitation programs and reintegration programs? And finally, from the representative from the Institute for Family, you, I think, highlighted, and many others as well, that a significant proportion of this problem is coming or is occurring among ethnic groups, indigenous peoples, as we've been hearing, but as well Afros and ethnic groups. I'm curious as to whether in all of these agencies, your different representations here, whether members of these communities themselves, the Afros, the indigenous peoples of the Cauca region, and so on, whether they are represented in these state agencies that are responding to the problem, and if they are or are not, are there opportunities for them to participate in the development of the policies and the programs responding to this problem? I'm particularly referencing here the request of the civil society that they sit down with you. I'm just curious as to what opportunities there are for that. Thank you very much.
Thank you. La comisionada Andrea.
Thank you. Andrea Pochak, Commissioner Andrea. Greetings to the requesters of this hearing and the distinguished members of the state. It augurs well that it's all women, the delegation that represents the state. I think this bodes well. But we recognize that there's no solution. There hasn't been a solution. That's huge problems that the government is facing, and all the difficulties to engage in dialogue with the armed actors and the boycott of all the political forces in Colombia. And therefore, we hail the commitment to total peace and the commitment to deepen peace and deal with these children, and recognizing the scourge of the forced recruitment of children, indigenous children, or any children for that matter. And thus far, what's been discussed at this hearing, we all recognize there has to be more forceful measures taken to put an end to these violations of the human rights of indigenous children. There's a commitment, there are proposals that have been put on the table. We have to pick up the pace. This is urgent. In 2022, the final report of the Commission was released for clarification of the truth which recognizes that thousands of children have been recruited forcibly. The Inter-American Commission has held up this report as being very important in the 2022 annual report. So the question that I pose to you are what measures have been taken to address these findings with regard to the forced recruitment of children since that time? What has been done by the state specifically after the reports of the Office of the Ombudsman with regard to, in the particular municipality, the forced recruitment of these children? What are the concrete obstacles that you have met with? Why can this not be prevented? Why is the number on the rise of these children who are forcibly recruited? And why does this scourge continue to exist? Tell us, what are the actual obstacles that stand in your way in dealing with this? Why would it be feasible to coordinate with your own prevention strategies and the strategies that are being proposed by the communities? I'm taking advantage of that. You have a few minutes more. We want to receive specific information about the criminal investigations that are underway, not only the protocols that are in place, but the particular criminal investigations and results, the status of those. These are gross human rights violations, and they are criminal acts, and we want to know what the results of these investigations are. And lastly, the Inter-American Commission is always going to advocate dialogue. There's a predisposition of the parties, the government. You don't need to have meetings with the Inter-American Commission. We're, of course, willing and able to help, but the conditions are in place so that there are discussions for coordination with civil society. And of course, we're going to follow up and track these. The April visit, we will continue to look at this. Thank you very much, Commissioner Pochak. I would like to greet, or rather hail, the effort of the Colombian state to reach out and address this dire issue. As has been said, there's been a lot of insistence. The Commission has underscored since 2013 this issue, this topic. Since 2021, it was identified in El Cauca, Nariño, Valle de Cauca, Antioquia, northern Santander, norte del San Juan. These acts of violence are particularly connected to non-state armed actors, particularly with regard in terms of forced recruitment of children and adolescents. We have this upcoming country visit in April, and there'll be an important stretch of the visit will be in Cauca, and we will deal and see it firsthand as we are doing now. But with regard to coordination with the state, as has been said, have been isolated efforts. What is the Office of the Ombudsman doing? Why is the Office of the Ombudsman not represented here is what I'd like to know. Fine. I don't know if anybody from the Secretariat would like to take the floor. The Executive Secretariat, Tanya Renault. Thank you very much, Commissioner, and good morning to each and every one of those who are here in front and behind, and the women in the front and the men behind. It's historical. And I'd like to ask those who are up on the screen from civil society who are joining us remotely. You have mentioned the precautionary measures and differentiated violations against campesinos in September of 2023. The Commission has been concerned in the Pacific area of Colombia. The violence has taken place, and there's a paragraph in that report which talks about differentiated follow-up of how women and children are impacted. I would like to know whether that if you, civil society, any of you could provide us with any facts, any information about, from your point of view and based on your experience on the ground, whether is it different for women and girls who are forcibly recruited? Has there been different treatment? What are some of the differences between them and males who are forcibly recruited? Thank you very much. Thank you. Assistant Executive Secretary. for monitoring. Thank you to everybody here and civil society organizations who join us remotely from the indigenous community and the high-level representatives of the state. We're precisely working on the country visit, which will take place from the 15th to the 19th of April, and as country rapporteur, and for the country rapporteur, it's a very important visit, and we need to go directly to El Cauca and the particular indigenous communities, Pueblo Nasa. In my view, we've taken note of the requests that the petitioners of this hearing have put forward to in designating and the Creek representatives for the negotiations in the framework of the total peace negotiations. I would like to ask, what are the specific initiatives that there should be participation, and what's the specific goal with regard to the phenomenon of this forced recruitment? What are you pursuing with this? And also with regard to including children and adolescents in the single victims, the single registry of victims. What has happened thus far is they have not been registered. They've been prevented from being registered, and this leads to underreporting, which has been pointed out here at this hearing. And also, I'd like to try to understand better the complexity that's been mentioned by the representatives of the state in terms of the phenomena itself and the different modalities and ways in which it takes place. And if you could enter into further detail, what is the situation in practice that you as indigenous community face day to day? That would be all I'd have to say now. Thank you very much, Maria Pulido. Now the ESCR rapporteur. Thank you very much, Commissioner Caballero and members of the Commission, and I express my gratitude to the organization and also to the authorities of the state for your clear presentation and attaching, and it's clear that you attach importance to this issue. I don't want to ramble on too much now. I just wanted to, as a rapporteur on political, economic, social, and cultural and environmental rights, the rapporteur, special rapporteur, I want to explain that what is entailed when there's forced recruitment for the human rights of children and adolescents. There's a lot of economic, social, political, cultural, and environmental rights involved here, and the conditions of violation of these rights, which makes it impossible that in a situation of forced recruitment, because these groups exploit the socioeconomic vulnerability of the communities to be able to carry out this forced recruitment, and therefore the strengthening and presence of the state in these affected communities beyond the specific center that hub that you talked about. But generally speaking, there have to be specific programs to offer viable guarantees, possibilities for these young people in protection of their economic, social, and cultural rights. This has to do with social development programs. This is related to programs for youth and for children, early child programs, etc. I'm sure you're considering this, and I'm sure since we're short of time, I don't want to delve further into this, but I'd be interested in knowing what policies are in place to ensure public services, these kind of social programs for children, for kids, etc., in that society. Thank you very much, Rapporteur. Now, let's start to wrap up. Civil society has 10 minutes, plus another 4 that had been added from not using their full amount in the original arguments. You can begin. Thank you very much. What we're going to do is forcibly recruited is 205 children in 2022 were forcibly recruited. This is the figure. In terms of the proposals of our organizations, the Family Wellbeing Agency has listened to the indigenous people, and there has been forward progress, but we haven't been listened to by the Office of the High Commissioner for Peace with a view towards the delivery, the return of the children. And so we'd like to bolster this proposal or propose it again or emphasize it. There's no, the victims unit, the children, victims or their family members have not been included in the single registry of victims yet. And this has caused a major problem of underreporting. And there continues to be threats of the forced recruitment. They continue to be faced and harassment by the family members. I will give the floor to one of my colleagues at this time to continue. Hello, good morning, everyone. Greetings to all participants. Can you hear me? Are you hearing me? Yes, we do hear you. We hear you. Okay, greetings from Cardono, Cauca, ancestral territory of the Tatamaquiwe in Cardono, Cauca, where there's about the Nasa people who belong to the Regional Indigenous Council of El Cauca. I would say that since the signing of the peace agreement in Colombia, the indigenous community harbored hopes of harmony, peace, that we were yearning for at that time. But over the last few years, the armed conflict ratcheted up in these territories. It's a physical and cultural extermination that we are subject to, that we are enduring. And more complex still is this forced recruitment of these young boys and girls, as mentioned by already. And of course, there is violence against women, even young women or girls who belong to different armed groups. I believe that the measures taken should be specific, geared towards the indigenous communities, and it's important to cite figures, but unfortunately, these figures are not really clear in our communities. They're not coming from our communities, and perhaps that's makes things worse in our communities. But what I would like to say, you, the Commission, we are now encouraged from you. We're on high alert because of these massacres of our young people, our leaders, our elderly leaders, ancestral leaders, our high-level officials. Things are getting worse. And that's why there is an armed conflict between the so-called guerrilla members, guerrilla groups, and revolutionaries. And we're so troubled by the situation on our territories, and we will hope that there can be coordination and tapping into harnessing the knowledge of our indigenous people, the government, and the Commission. And this is absolutely urgent to our territory. Thank you very much for the opportunity, and we're very grateful to you all.
Un saludo de resistencia y hermandad.
Greetings, and thank you, ISCHR, for enabling us this opportunity. Alejandra Casamatin from one of the civil society organizations. More than giving you figures which are sorrowful, But we have proposals instead of giving you figures and statistics. Sad statistics. As indigenous people, we have enabled in the framework of a resolution and this dialogue for peace. There's 3 stages. The humanitarian context. We want to get these children and minors out of this warfare who have been forcibly recruited. 3, and to save the life of the leaders, community leaders, and others who have a high profile and they've been targets of assassination. And then also an advocacy policy. Our council and the CRIC in the negotiations about the total peace accords and the ELN, we need to be at the table and talk about the cultural aspect, and not only the cultural things that are strategic and important for us, but much more. We put forward a document that, and so we've given this to the FARC for the negotiations, but there has to be a mechanism that leads to peace, so it's a comprehensive peace. And we must restore the rights of children and adolescents. And we all should also become part of subsequent processes to eventually sign agreements. The High Commissioner of Peace, Mr. Patiño, and also the Ministry of Justice as well. We are emphatic, we're adamant about this, that we need to lay out the roadmap towards peace. And this has to do with a particular roadmap that has been put forward by the Central Command of the FARC. And children under 15, under 15 must be taken out of the picture. We must include this. We, as the CRIC, our organization, we're engaging in dialogue. We're directly engaged with the armed actors. We know that it's centralized, but our indigenous, our traditional government, and we're recognized internationally, and so we are entitled to directly engage with the armed actors, illegal armed actors. And so we would call on the Office of the Attorney General and the government to listen to what we're doing in our engagement. We're laying out a roadmap because we're autonomous and we are availing ourselves of that designation as being autonomous in our government and justice. And so we'd just like to bring to your attention to be aware of this roadmap we've laid out directly with the armed groups. And the conflict is getting worse and worse. We want to let the ICHR know about this in advance of its trip in April, its country visit. Thank you very much. If there are no further requests for the floor from the advisor of Greek is going to speak now. Hello, good morning. I'd like to hail this opportunity and for the Indigenous Regional Council, along with the other authorities of Sakta-Makiwe and other indigenous groups. And these 2 territories I just meant, together with other territories in El Cauca, is where the armed conflict has become heaviest, particularly with this forced recruitment of young people. And it's very important to reiterate that this regional council has banked on this peace negotiation for a time now. We've put forward a proposal for peace, not only for the indigenous movement, but the entire country. We want to put in place conditions so that our voice, our word, is heard in the different scenarios that are being created by the government so that we can move forward towards peace in Colombia. We cannot let history repeat itself where civil society is the last one listening, particularly indigenous people who come in at the 11th hour. We cannot avoid such a situation. We must avoid this situation. We must do something. I call on the ICHR, if it is able to intervene and say something about the importance of the voice of indigenous people. We suffer on the ground on a daily basis as a result of the armed conflict, and in this particular case, the recruitment of children and adolescents from our community. So we have a specific proposal that we've been working on with the High Commissioner for quite a while, also with family welfare, also with the United Nations, with regard to a proposal to deal with our children. It's been very tough for us at times for the government to heed our proposal. But this effort is solidifying and it's enabling us to be heard, and we're engaged in coordination efforts so that the proposal can really do something. This is how we build on what we have, the feelings and the actual communities that live in these territories, and we call for greater openness by the government agencies to listen to us and to build with us, not build from their desktops in their offices, but to sit down with us on the ground. And I respectfully call on you to take into account the indigenous movement's word from El Cauca so that we can address these different scenarios. This is geared for us to be actually involved in this humanitarian dialogue so that we can have an actual peace. We are continue to engage the way we've been engaging, to safeguard the lives of many of us who live in our territory. This is specifically, I want to salute your country visit in April. I think it's very important for you all to see this firsthand and to come into the territory and see with your own eyes what we see on the ground day after day. There's 4 or 5 cases that we deal with on a daily basis with regard to these murders and forced recruitment, and high-level officials often don't pay attention, but the Indigenous Council continues to be committed to building peace, and we will not stop until we actually we have this balance and harmony, not only among indigenous people, but all of Colombia. Thank you very much.
Muchas gracias.
Thank you. I'd now like to give the floor again to representatives of the state for the allotted time. Go right ahead. I'll pick up where I left off. The Colombian Prosecution's Office has a great deal of jurisprudence with regard to these matters. We are focusing our efforts and our institutional resources to make sure that the people who are responsible for these atrocities are brought to justice. Going a mile a minute, my dear, nobody can follow. Just as fast, the result of these actions are now 1,500 recruitments over the last 20 years. It's the ELN that is principally responsible, the GAO, the Gulf War people are also there, the heads of FARC, and the heads who decided to come forward and presume to be part of the peace process. We do want to underscore how very seriously this has affected boys and girls. 50% of the entire cases in Colombia involved young children. El Cauca, Valle Chocó, and Nariño and other regions were principally affected, Putumayo and others. More than 80% of the cases of illicit recruitment and the abuse of minors come from these places. Between 2021 and the last day of 2023, we have illicit recruitment and 4 cases that are open with regard to victims that are all indigenous. 12 youngsters in 2022 who are in our files then, 85 of the victims in the next case for 2023, 205 are children, and we have 12 thus far. All of this to say that this continues to be a very serious issue. It's not going away. We have 33 open investigations, of which 19 have been closed or have led to clear indictments. But there are circumstances in which the overall complexity of the matter has not lent itself to these results. We need to better understand the criminal structure and have other people like human rights and peace militants include. Within the Justice Department, we now have a special research department, investigation department for these matters. Many of these have been deepened in El Cauca, and we have the following results. The FARC incidents, Coarenas, a great many local names are being rattled off, I beg your pardon. 89% of the cases were fully investigated. Jaime Martinez, 38 cases are still being worked on. That's 73%. The FARC presence is Coronel Patiño, 20 cases. 90% of those cases are progressing. The ELN, Jose Maria Becerra, 3 cases where all cases have been now clarified. We have a great many more details, which we are pleased to offer you, have it in writing. But what I'm trying to tell you is, and this is important, these issues are not being looked at seriatim or without any reference to the other cases, because there's a great deal of commonality amongst them all. Thank you very much. Thank you very much for all of the questions that you have asked and your interest. There are a lot of questions and concerns, but a very, very little time to satisfy you, perhaps. I'll try to drill down on 5 points. First of all, the extraordinary complexity of this matter, sexual exploitation of these youngsters, which several of the commissioners mentioned. The other question is the interinstitutional impact through CIPRUNA, the peace negotiation tables, the precautionary measures, and the references that have been made here to the judicial responses, all of which were mentioned by the various distinguished commissioners. So let me try to answer as best I can. There are deep and complex structural reasons why these matters continue to be a scourge. Boys, girls, and others must be looked at not only in terms of the internal, that is the domestic conflict, but also the lack of sufficient respect, aside from the war element, insufficient knowledge and respect of the rights of the children. And another point that I'd like to say is that we need to do better in ensuring that those youngsters don't see joining the armed groups, whether convinced or seduced or otherwise lured into, or any other reason, don't see joining those conflicts as a way out of their own bogged down situation. The use of these lures very often comes through third parties, through criminal parties, and that makes it, of course, infinitely more difficult to trace this back and pinned on the actual well-known war groups. That is first gloss and very quick brush to the questions you've asked. As to Cipruna, Cipruna is a space, as one calls this sort of thing, that involves 22 entities. Each one of them has its own institutional response to this problem of recruitment. What I was suggesting is that given the extreme complexity of the situation on the ground, there should be a more cogent offer on the part of Cipruna that is tailored to the different territories. That is, the dialogue with the indigenous peoples should certainly recognize the indigenous authorities. That seems like a no-brainer, does it not? Cipruna needs to broach all of this, we believe, with a clearer sense of the institutional component here and not just be blinkered by the territorial element. And the approach needs, of course, to involve the territorial authorities and the indigenous leaders, but that's how we are now trying to beef up Cipruna and make it more effective. On the peace process, let me simply say that with regard to the question of recruitment, we have a proposal on the table with the FLN. Recruitment of minors is right out there in every single context of the tables that are discussing the peace process. Every one of them. There are different aspects that are broached in different tables, but recruitment of minors, that is, kids under the age of 15, is everywhere. It's not going amiss or undetected. Feliciano Palencia, who is a leader among the indigenous peoples in the Cauca, is committed thereto. The High Commissioner has also received proposals from the CRIM, and we are still waiting for written responses. Let me, in fourth place, refer to the precautionary measures. There is a very strict follow-up on the Foreign Ministry side. Back in August, we met with the CRIC precisely to consider the precautionary measures and what was being done and how well they were being implemented. And we had good contact with that important indigenous forum. Each one of the precautionary measures, of course, need to be focused on individually. But there is an overall responsibility that goes to our foreign ministry within Cipruna. And we offered technical assistance to the 35 townships of El Cauca, and that was a specific recommendation of those measures. As regards minors, let me say that above all, the state of Colombia recognizes the minors that have been cut off from their families are considered victims in every sense of the word, and indeed they are. That also has pointed to particular criminal liability for those who have been guilty of recruitment. You are being very, very detailed, and we've got to wrap it up, says the chair. I'm awfully sorry. All right. I just want to say that the Ministry of Justice has special programs, and we can send you more information on these, to strengthen the support to the children and more clearly establish special justice within the indigenous context and the national context. Thank you very much. Thank you very much. This closes the hearing, ladies and gentlemen. Thank you very much indeed for the information that civil society and the state has provided, and we will see you again on April 15th to hear the State of Colombia at that time. Thank you.
Muchísimas gracias por el espacio y por permitirnos la palabra.
Muchas gracias por escucharnos.
Good morning, everyone. Welcome to hearing number 4, the right to integral reparation for victims of the armed conflict in Colombia. This hearing will last 1 hour and 30 minutes. And I want to welcome representatives of civil society, and I want to welcome representatives of the state, and in particular Ambassador Vargas, who was a former member of the Inter-American Commission on Human Rights. Welcome home, Ambassador, and again, all of the representatives of the state. And it's perhaps fitting at this point that I recognize that this year, the Commission is celebrating its 65th year of existence. And that's something we're very proud about. And it's 65 years of being committed to the defense and the promotion of human rights in the Caribbean and the Latin and in the Americas. And it's 65 years of giving life, especially to the American Convention and the Democratic Charter. Since 1959, we've had hundreds of professionals come through the Commission, as well as also, I think, nearly 50 commissioners, nearly 50 commissioners. And thousands of civil society representatives have also come to the Commission seeking voice and seeking audience and seeking a listening ear as they ask for the support of the Commission to promote and protect human rights. We celebrate 65 years, including 100 on-site visits. Over 1,000 precautionary measures have been granted. More than 750 merit reports have been written by the team of the Commission, 220 friendly settlements, and we seem to be getting more of that, which is a good thing, and at least 377 cases sent to the court. So there is a history of work in the Commission and a history of impact, working closely with the victims as a central focus of our work, but also working with the state, because state accountability really, after all, is what we are working for. So that's to celebrate our 65th year of existence. I also want to say something on accessibility. To ensure that this hearing is as inclusive as we can make it, we ask all participants to begin your presentation by stating your name, your position, and the organization that you represent. And every time you take the floor, please do repeat your name so that those who are visually impaired and online can identify who is speaking. Likewise, we remind you that these audiences have Zoom titles available. So if you are online using Zoom, please remember that you can have subtitles, your subtitles turned on, as well as interpretation. I'm speaking in English, but there's interpretation, of course, in Spanish that's available online. So each person can directly activate your interpretation and your subtitles from your own computer. So with that, I also want to tell those who are online that you can follow this hearing through the Commission's channels, Facebook, live stream, as well as Instagram live stream. So we have other ways to see this. Okay, on how we're going to organize this hearing. We started with civil society. You will have 20 minutes. And then we give the state the same time, 20 minutes. We have comments from civil society, or the Commission will have 20 minutes to ask questions or give clarifying statements if they wish to. The civil society has another 12 minutes to respond to the questions that the Commission has asked. Similarly, the state has 12 minutes, and then we close the session. When you begin to talk, you'll see it right there, the 20 minutes, the clock is on the screen, so you can monitor what you're going to see. And we are pretty rigid about the time, so we ask you to please follow your time closely. With that, I turn over to the representatives of civil society to begin their statement, and please do remember to say your name and your organization.
Buenos días.
Good morning, Madam President Clark, Commissioner members, and members of the Executive Secretary, and the delegation of the distinguished state of Colombia, and those who have joined us for this hearing. My name is Maria Paula Lemos of CAJAR. Next, together with other human rights organizations of Colombia, we're going to present 3 of the major concerns with regard to the obstacles and regression with regard to reparation for gross human rights violations in our country. Firstly, we will talk about the restorative measures that were adopted in the special jurisdiction for peace, JEP, GEF. Secondly, we would talk about obstacles within implementing Law 1448, known as the Victims' Law. Thirdly, we will talk about the regressive application of lapsing of time for claims for reparation. And lastly, will issue our recommendations. The organizations, recognize the JEP to get to the bottom of the truth in some cases. However, in order to improve implementation of the different strategies whose purpose is to centralize services for the victims, we have several concerns. The mandate of the JP includes a restorative approach to justice. In macro cases, the major cases, those perpetrators have recognized their responsibility, and there has to be a conclusion, a formal conclusion that conclusions, among other things, the punishments based on the proposals for reparation of those who are the perpetrators who appear before the jurisdiction. One thing, in case 01 and 2, case 03, murders and forced disappearances in combat by agents of the state. However, in neither of these two cases have the observations and input of the victims been taken into account sufficiently. Now, however, even though the JEP jurisdiction is in charge of determining what the punishments will be for those who appear, the perpetrators of the crimes, but it can change the draft brought forward. But there's concern as to whether these measures have a restorative and reparative content in view of the damage that has been caused to the victims for which they're being tried, the perpetrators. And then it's determined whether the restorative justice that have been put forward before the JEP for the perpetrators, it's decided whether it meets the requirements.
Sorry to interrupt you. Can you speak a little bit more slowly for the interpreter?
Okay. No obstante,
nonetheless, in this scenario, there's no roadmap that establishes that at the beginning of this proceeding, the parties should be served notice. It's not ensured in all cases that their right to participate in the appropriateness of the implementation of this type of laws. In the framework of defining the criteria for imposing restorative punishments of the perpetrators, there was a decision that was issued in 2023 establishing that a parameter of categorizing the different perpetrators to fulfill their obligations in providing reparation. Depending on the degree of responsibility, these actions with the restorative content can range from 15 years at the most to 2 years. And this questions the proportionality and appropriateness that there should be in a reparative approach in keeping with international standards. Based on these criteria, the HEP has ordered agents of the states linked to case 03 to adopt a restorative approach within 6 months. In Catacumbo, it was decided that they serve social service, but the victimizing case in the Caribbean coast, there was an ecosystem reparation decision. The failure to implement an intersectional approach as decided by the decision makers. There was an extrajudicial execution of a pregnant woman. And lastly, the HEP will implement the restorative system with certain guidelines which were not agreed upon with the victims, disregarding the central nature of this, with 3 drafts which were not shared with anybody and did not meet the expectations of the victims. Now I give my colleague the floor. Good morning. My name is Viviana Rodriguez Peña. I'm the Corporación Humanas. I'm one of the attorney, and I'm speaking with GEPAS and other cases I'm going to talk about with regard to the transitional justice and with regard to implementation of a gender-based approach in these proceedings. What we notice is that recognition of violations against women and LGBTQ people in the macro cases are just getting started. It's in its infancy, understanding that this violence are separate from the war strategy, and they haven't been brought together with all the complaints brought forward before the JEP. We find, however, that the order of case 02 that talks about violence against women and LGBTQ people in Nariño is progress, and we hope that this seeps into the other major cases. However, there has to be a clear strategy and to get to the bottom of this violence beyond the initial version or story that we're given, and to document and recognize this reproductive violence that's not only sexual based, but there's another type of violence. And so there's been many reports on violence with a great capacity to explain quantitatively and qualitatively. The JEP continues to repeating that there's not enough information on the acts, but there is enough to establish responsibility and criminal liability. There has to macro case 11 must be focused on and apply there has to be an adequate investigation and evidence gathering. We recognize the input of the special investigation for sexual crimes to overcome these deficiencies, that even though it is willing and to engage in these adversarial proceedings, but it's been going on for 5 years now. We urge the JEP to activate macro case 11, accrediting the victims and take into account the lessons learned in the other macro cases and focusing on the voids that still exist. Additional delays are plaguing transitional justice, and there's no willingness or capacity to deal with the violence against women and LGBTQ people. While this is going on, victims are facing high risk and others have passed away. Justice cannot continue to make them to wait. In this backdrop, what can be the restorative measures that traditional justice can impose here if we don't deal with women and LGBT people? The restorative system that has been mentioned by my colleague continues to be a separate category. In this, it's macro victimization and they're considered separate, and so but it should cut across everything. In the macro cases, with the conclusions, there must be restorative justice, and the gender-based violence is not being taken into account together with everything else. So JEP reported that it has a parallel strategy, which it called early reparations, which is under the investigation and accusation unit, an entity that says it deals with reparation without the need for it to be a consequence of any judicial proceeding. So how can a judicial mechanism provide reparation without any judicial decisions? How can JEP characterize any harm, colorable claims, when there's no connection between the two systems? To understand the demands and needs for reparation of the victims of these adversarial proceedings and the competence of the JEP, there has to be built a medical center focused on victims of this form of violence and complementary measures. Thus far, we know the contribution that's been made by this body with regard to providing a reparation to LGBTI people and women. The government has reported to us that JEP, there's been 155 billion pesos for the peace fund for this early reparation program. So it seems at first that it's a way of meeting the needs of these women to provide reparation for this violence during the armed conflict. But most of the victims have not learned exactly what this reparation is. It's an imposition of 100 women and LGBT people who have entrusted this to the head and have not called upon to receive their reparation or restoration. And they're receiving public resources, and there's no oversight, and it's not in contact with the prosecutorial body. So transitional justice cannot say now that to provide reparation for the violence, we can do without our participation. The second thing the organizations want to address is the obstacles to implementation of the Victims' Law, Law 1448. This law lays out a policy of reparation for victims of the armed conflict in Colombia. But after 12 years after it's been enacted, there's challenges for its implementation. Firstly, funding to provide funds to all the people who are included in the registry. People who have been declared victims, but they've received no reparation from the government yet. This includes several women who are victims of sexual violence. The national government keeps saying it doesn't have enough budget, and its main action is applying a prioritization policy that leads people waiting forever for their reparation. It's urgent that the current response of the government shows greater willingness to provide the compensation. And while this is fulfilled, the victims should see other measures such as rehabilitation, satisfaction, restitution, memory, and non-repetition. The second challenge we identified has to do with the concept of the law of victims, the Victims' Law. This expresses situation. Firstly, people who were recruited by armed group who were under 18 years of age, but they demobilized by 18 years of age, and they lived among the ranks, and there was violence, gender-based violence they experienced. Among these people, the WADIF, which is a reparation unit for victims, denies the condition, their status as victims. This is despite the fact that the Constitutional Court in its sentence 599 said that overturned this decision as unconstitutional, and this was reiterated by the Truth Commission in its final report, and it recommended the national government to adopt all necessary measures to overcome this obstacle. We urge the government so that the solutions are not just about legislative reforms. The second situation with regard to the concept of victim is suffered by those who are victims of extrajudicial acts. There's a void of victims and outlawed groups, and they're denied appearing on the registry. Their families report that the officials do not take their statements, or they say that the perpetrator of the acts committed by non-state actors is not recognized. And so we need to have them recognized and appear in the registry. The third thing is implementation of Law 1448. The next challenge is that when the DEP recognizes these people as victims, but they're denied reparation, or they're told that there has to be additional proceeding, they have to prove they're being victim once again to be able to have access to the administrative registry. So there's a need for the state to coordinate to ensure unified criteria to recognize the right to reparation. This disregard, official disregard for the story of the victims, no access to housing, education, and health, and handing over the remains of people who were disappeared, not only economic reparation, it's the full panoply of reparation has to be provided. And now I give my colleague the floor to finish up. My name is Sofia Bautista, member of the Colombia Commission of Jurists. Next, we will submit to the consideration of the Honorable Commission how the legal precedents of the Constitutional Court and the courts has ruled on reparation, has denied the rights of the victims and the obligation of the state for in the face of crimes against humanity and crimes, war crimes, as international laws prescribes. The means against direct reparation is that the victims of these violations must have access to justice and measures of reparation. In the past, the Council of State enforcing the convention had determined that there was no time-barred nature to these claims, and they would be able to have access to reparation. But then 2 years was set as the time limit to be able to put in a claim for this. And so there's great vulnerability and a lack of security to be able to do so, to file their claim within 2 years. But in 2020, however, the Council of State issued a unifying judgment in which it disregarded the rights of the victims in a case, an international case against Chile. It says that 2 years since they learn about the crimes, even when there are war crimes and crimes against humanity, there was a 2-year limit to file the crime. Additionally, in another judgment of 2020, the Constitutional Court decided a protection claim and decided it was proportional and reasonable from a constitutional point of view and under the convention. The interpretation of the Council of State and the 2-year time bar. So the limits put on based on the legal precedents, it should be retroactive, and anyone should be able, in cases of crimes against humanity and war crimes, they should be able to file their claims for reparation. And this is seriously affecting their right to legal stability, legal certainty. The right to access to justice is being and protection against non-aggressivity with regard to the victims. As proof of this, we have learned about 22 cases in which there had been a recognition to provide compensation for responsibility of the government, but they were not given this because there had been a lapsing of the claim. And so there were many petitions before the Inter-American system to obtain recognition of these rights in light of forced disappearance, even though there's special rules in this. But with regard to the lapsing of the crime since the time of the events or since it was reported, without the body having been handed over to the family members, but against the Inter-American Court's legal precedents, they have not respected this, and there's been a disproportional effect of those who are the victims of sexual violence by the public security forces. And there should be enhanced protection against women in this regard. There's no differentiated approach to this when it comes to the perpetrators and the victims. All of this it rides roughshod over standards and guidelines that have been established with regard to the rights of victims established by the UN and the case law of the Honorable Inter-American Court. To wrap up, the organizations call on the Commission to take into consideration the challenges that have been brought up now and call on the Colombian state to take all necessary measures to comply with the international standards when it comes to full reparation to the victims. Secondly, that the JEP take affirmative concrete action so that there be a culmination with explicit recognition of sexual violence, reproductive violence, and ensure the participation of women and LGBTQ people in defining what can be the reparation and restoration they receive. And thirdly, to take restorative measures, putting the victims at the center, including actions in which the perpetrators have to proportionally take into account age, culture, and other intersectional factors. 4, to adopt necessary strategies to overcome obstacles in implementing the law of victims. That is, change the third article of the law and eliminate the restrictions and ensure the necessary budget to be able to provide compensation to the victims under a plan, and don't make victims wait forever, indefinitely. And lastly, activate the mechanism to coordinate between the different agencies involved in the JEP and others to include the victims in the registry and respecting the duties of each agency to respect the measures of reparation so that it provides proper reparation to the victims. Lastly, recommend to the state to adjust the domestic decisions and legal precedents to international standards when it comes to serious human rights violations and crimes against humanity, as hashed out by the Honorable Inter-American Court. Thank you.
Thank you very much. I now turn over to the representative.
Muchas gracias. Tiene la palabra la representación del Estado.
Para todos ustedes, en nombre del Estado colombiano, un saludo muy especial. A los miembros de la comisión, tenemos aquí a nuestra presidenta Roberta Clark, el segundo vicepresidente y comisionado para país, José Luis Caballero, la comisionada Andrea Pochac, y estos dos fenomenales trabajadores que tenemos en la Secretaría de la Comisión, María Claudia Polido y Jorge Mesa. Un saludo muy especial a las representantes de las víctimas, solicitantes de esta audiencia, a los miembros de la sociedad civil y a quienes me acompañan aquí en nombre del Estado. Gracias, querida comisión, por haber seleccionado esta audiencia, porque al fin y al cabo es un espacio que tiene el Estado para dar continuidad a un trabajo que se hace de manera muy respetuosa con la comisión para buscar que el tema de reparación a las víctimas realmente sea una realidad. Me acompañan en la delegación, y empiezo por las mujeres, como debe ser siempre, Mariana Ardila Trujillo, directora de la Justicia Transicional del Ministerio de Justicia, Patricia Tobón Yagarí, es una indígena que nos representa muchísimo, que le da muchísimo lustre al Estado, que se encuentre hoy como directora de la Unidad de Víctimas, y el presidente de la Jurisdicción Especial para la Paz, Roberto Carlos Vidal. Hasta hace poco los veíamos allá, al frente, donde están hoy los solicitantes, hoy están aquí en representación del Estado. Y debo mencionar que las víctimas del conflicto armado fueron partícipes de la negociación del acuerdo final de paz. Por ende, como fueron partícipes en ese acuerdo firmado en 2016, son el eje fundamental de ese acuerdo. Con este instrumento de paz y la subsecuente creación del sistema integral de verdad, justicia, reparación y garantías de no repetición al que pertenece la JEP, el Estado busca satisfacer integralmente los derechos de las víctimas. El Estado colombiano estableció un diseño institucional y una normativa que se ajustara a los estándares internacionales, que se pudiera proteger y garantizar el derecho fundamental a la reparación integral. Eso es lo que quiso siempre, y debemos decir que la superación del conflicto armado en nuestro país es, sin lugar a dudas, un desafío muy grande y en el cual requerimos nosotros del acompañamiento internacional de los estados. Hay enemigos muy poderosos de la paz allá en Colombia, pero Colombia le apostó a terminar este conflicto en forma definitiva, y en esta tarea el gobierno está poniendo todo el esfuerzo institucional en un desafío que no debería ser así, pero se nos ha convertido en uno de proporciones históricas. Para el gobierno nacional es prioritario e indispensable alcanzar una paz estable, duradera, esa es la verdadera garantía para que haya en esa política de paz total el camino que nos permitirá profundizar la democracia, superar el conflicto armado y a través del diálogo y de acuerdos de sometimiento a la justicia con actores armados al margen de la ley, superar, ojalá, en forma definitiva, toda esta conflictividad. Dicho lo anterior, le cedo la palabra entonces a la directora de Justicia Transicional, Mariana Ardila Trujillo, Ministerio de Justicia.
Buenos días a la honorable comisión y a las organizaciones solicitantes. Colombia cuenta con varias vías judiciales y administrativas no excluyentes para garantizar el derecho a la reparación, modelo que está en constante ajuste debido a la complejidad de los conflictos armados que aún vivimos. En primer lugar, en el marco de la Ley de Justicia y Paz, creada para el sometimiento a la justicia de grupos paramilitares, el proceso penal especial cuenta con un incidente de reparación. Las indemnizaciones son cubiertas por el Fondo para la Reparación de las Víctimas, el cual se conforma de varias fuentes de recursos. Hoy, la mayoría de las reparaciones están siendo cubiertas por el presupuesto público debido a limitaciones de la figura de la extinción de dominio, la cual estamos ajustando. La segunda vía es un programa masivo de reparación administrativa para más de 9 millones de víctimas que pretende cobijar todos los componentes de la reparación, no solo la indemnización, y que reconoce un conjunto amplio de violaciones de derechos humanos, incluidas diversas formas de violencia sexual. Es el programa administrativo de reparación masiva más ambicioso a nivel global, ya que ningún otro país ha intentado reparar un universo tan grande de víctimas, aproximadamente el 14% de su población. Ningún otro programa de reparación administrativa ha registrado o reparado a más del 2% de su población. Desde el 2011, el Estado ha invertido cantidades considerables de recursos en este proceso y ha logrado compensar a cerca de 1,5 millones de víctimas. Sin embargo, frente a la magnitud de la victimización en el país, esta suma solo se acerca al 20% del total. Producto del acuerdo de paz, se previó que el programa de reparación administrativa debe ser fortalecido. Como veremos, el gobierno está dando pasos decididos para ello. Finalmente, las víctimas cuentan con varias vías judiciales: la reparación en el marco de los procesos penales contra los responsables de violaciones de derechos humanos y la reparación directa para que el Estado las repare por la acción u omisión de sus agentes. Hay que precisar sobre los precedentes citados por las organizaciones solicitantes que el término de caducidad de 2 años solo inicia a contabilizarse desde el momento en el cual los interesados tienen conocimiento de que el daño es imputable al Estado y siempre que se encuentren materialmente en posibilidad de acudir al aparato judicial. A pesar de que todas estas vías de reparación son variadas y complementarias, sabemos que requieren ajustes, por lo cual en el último año y medio hemos emprendido varias acciones para abordar las preocupaciones expresadas por las organizaciones solicitantes, específicamente en 2 escenarios propiciados por el gobierno: el proyecto de reforma a la Ley de Víctimas y Restitución de Tierras y el proceso de reformas a la justicia. De un lado, a finales del año pasado, el gobierno inició un proceso para construir un paquete de reformas a la justicia, con el fin de acercar la justicia a las comunidades y territorios en mayor vulnerabilidad, lo que incluye a las víctimas del conflicto. Para ello se conformó una comisión amplia y diversa y está recibiendo aportes de la ciudadanía. Invitamos a las organizaciones solicitantes a presentar a esta Comisión de Reformas a la Justicia sus propuestas de reforma a los estándares de reparación en sede judicial. Por otro lado, el año pasado el gobierno radicó ante el Congreso un proyecto de ley que busca reformar la Ley de Víctimas, que contó con participación de víctimas, comunidades étnicas y ciudadanía en un proceso liderado por la Unidad de Víctimas y apoyado por los Ministerios de Justicia y Agricultura. Con este proyecto se busca superar los rezagos en la reparación, abandonar el enfoque asistencialista para adoptar una de soluciones duraderas, con especial énfasis en educación, vivienda y generación de ingresos, armonizar el programa con el Acuerdo Final de Paz de 2017, reconocer a víctimas que están excluidas del registro y fortalecer la financiación. Todos estos aspectos están relacionados con las preocupaciones planteadas por las organizaciones solicitantes. Hay 5 medidas que quiero resaltar. Primero, el proyecto prevé 2 fuentes adicionales de recursos para las reparaciones. Segundo, propone crear una comisión de financiamiento que adoptará las recomendaciones anualmente sobre fuentes de financiación para la política de víctimas, las cuales deberán ser revisadas y adoptadas por el gobierno. En tercer lugar, de manera explícita, se añade el enfoque de género y derechos de las mujeres y personas con orientación sexual e identidad de género diversa. Cuarto, se plantea una ruta especial de inclusión de víctimas acreditadas por la Jurisdicción Especial de Paz y reconocidas por la Unidad de Búsqueda de Personas Dadas por Desaparecidas. Quinto, se propuso también una reforma a la Ley de Justicia y Paz para permitir en varios casos la venta temprana de bienes antes de la extinción de dominio y así impedir el deterioro y pérdida de vocación reparadora de los bienes. Este proyecto cursa actualmente en el Congreso y el Gobierno está comprometido a impulsar su trámite, mientras seguimos, bajo las normas actuales, acelerando la implementación con varias medidas respecto de las cuales le doy la palabra a la directora de la Unidad para las Víctimas.
Buenos días. En respuesta a las observaciones realizadas por las organizaciones de derechos humanos, me referiré a los siguientes temas. Primero, sobre las víctimas incluidas en el Registro Único de Víctimas, consecución de recursos y medidas de reparación implementadas, y en segundo punto, sobre el acceso a información y estado de trámite. En cuanto a las víctimas incluidas en el Registro Único de Víctimas y la consecución de recursos y medidas de reparación implementadas, es importante recordar que al 31 de enero del año 2024 el Registro Único de Víctimas reporta 9.625.203 personas, de ellas 8.578.269 son víctimas de desplazamiento forzado. Del total, 7.586.187 son sujetas de atención de diferentes medidas. Con el objetivo de contribuir a la superación de los rezagos en la política de atención y reparación integral a las víctimas del conflicto armado, el Gobierno Nacional presentó al Congreso de la República en el mes de octubre del año 2023 el proyecto de ley de reforma para la actualización de la Ley 1448. De 2011. Este proyecto busca articular y garantizar que la política de víctimas esté en línea con lo establecido en el Acuerdo de Paz y contribuir a la búsqueda de nuevas fuentes de financiación para el cumplimiento de la política de víctimas. Para superar las barreras de acceso al registro, esta iniciativa propone adoptar un enfoque de género y diferencial más garantista, amplía la definición de víctima, incluyendo a excombatientes que hayan dejado las armas y que hubieran sido víctimas de graves violaciones a los derechos humanos y al derecho internacional humanitario, estando en las filas. Adicionalmente, en atención a los delitos de violencia intrafilas, incluida la sexual y reproductiva, la unidad se encuentra revisando aquellas barreras jurídicas y técnicas que limitan su reconocimiento en el registro y poderlas incluir en él. De la misma manera, en diciembre del 2023 fue proferida la Ley 2343, la cual establece nuevos plazos para la realización de la declaración. Ahora las personas tendrán 3 años para declarar a partir de la ocurrencia de los hechos y las personas que no han declarado hechos ocurridos hace más de 13 años tendrán plazo hasta el 29 de diciembre del 2024 para hacerlo. En materia de consecución de recursos y medidas de reparación implementadas, el Plan Nacional de Desarrollo 2022-2026 Colombia, Potencia Mundial de la Vida, ha reconocido la necesidad de contribuir en la disminución de los rezagos de la política de atención y reparación integral a víctimas. Es así como a través del decreto 1234 de 2023 se efectuó una adición presupuestal de 200.000 millones. Los recursos del presupuesto más esta adición nos permitió indemnizar el 10,84% del total de personas que han accedido a la medida, 143.000 personas. Asimismo, para el año 2024 se logró un aumento presupuestal adicional del 37%, siendo la asignación más alta en la historia de atención en materia de indemnización. No obstante, a pesar de los avances, somos conscientes de que el reto presupuestal persiste, por lo que se propuso entre el proyecto de reforma de la Ley de Víctima obtener mayores recursos mediante fuentes alternativas de la financiación. En materia de reparación colectiva, este Gobierno asumió la meta de formular y concertar 642 planes de reparación colectiva y avanzar en la implementación de 300 líneas de estos planes con enfoque de género, constituyendo la meta más alta en atención a la reparación colectiva a víctimas del conflicto armado en toda la historia de la política. Ahora bien, en cuanto a medidas de reparación implementadas por la unidad, desde el 2011 a la fecha se han indemnizado individualmente 1.323.895 víctimas. De estas, 719 son mujeres, 354 personas se reconocen como población LGBTIQ+, y 234.743 personas se reconocen con una identidad étnica. Por último, en relación al sistema de turno para el pago y la priorización de indemnizaciones, hoy se cuenta con una resolución, la 1049-2019, que adopta el procedimiento para reconocer y otorgar la indemnización individual con el fin de brindar mayor celeridad, y acá aplicamos el método de priorización y la propuesta técnica y operativa define también criterios de priorización con enfoque diferencial que también tiene en cuenta los contextos territoriales y la reparación de la población en mayor situación de vulnerabilidad. En materia de acceso e información de los trámites, la unidad ofrece asesoría y orientación en 185 puntos, con atención presencial en el país, 32 centros regionales articulados con las entidades territoriales, y brinda también atención en canales telefónicos virtuales de manera gratuita. Finalmente, entregamos a la Secretaría Ejecutiva de la Comisión y a las organizaciones sociales un informe detallado que da respuesta a las inquietudes y observaciones planteadas para la audiencia. Muchas gracias.
Buenos días, yo soy Roberto Vidal, presidente de la Jurisdicción Especial para la Paz. La reparación integral de víctimas es un deber en cabeza del Estado en su conjunto, frente al cual la Jurisdicción Especial para la Paz tiene un mandato específico que se consolida en la garantía del acceso a la justicia transicional, el aporte a la verdad y a la satisfacción de las víctimas a través del reconocimiento de los responsables de crímenes y su contribución a la reparación a partir de trabajos, obras y actividades con contenido reparador y restaurador. Una de las mayores innovaciones de la Jurisdicción Especial para la Paz es la relación que establece entre justicia transicional con justicia restaurativa. Esto ha implicado integrar un contenido muy alto de participación de las víctimas desde el principio de los procesos judiciales, lo que implica propiciar el encuentro entre víctimas y responsables, diseñar sanciones restaurativas y la ejecución de trabajos reparadores que sean significativos para las víctimas y las comunidades en los territorios. Para lograr esa participación, en la jurisdicción ofrecemos acompañamiento, información, acompañamiento psicológico, representación jurídica para las víctimas, de manera que podamos hacer lo que hemos llamado participación integral. El año pasado, la jurisdicción culminó el proceso de apertura de casos, que en este caso, en el caso de la JEP, se trata de casos masivos, con miles y a veces decenas de miles de conductas, miles de víctimas y cientos de comparecientes. La JEP definió que trabajamos en su condición de jurisdicción temporal, trabajamos sobre 11 macrocasos. De esos macrocasos, el último es denominado violencia basada en género, violencia sexual, violencia reproductiva y otros crímenes cometidos por prejuicio basados en la orientación sexual, la expresión y o identidad de género diversa en el marco del conflicto armado colombiano. El universo de víctimas en el que hemos trabajado en este momento es de 35.000 en 50 años de conflicto. El 90% de esas víctimas son mujeres. Ahora bien, hemos abierto unos procesos de participación para las víctimas en diversos momentos del procedimiento. A todo lo largo del procedimiento de la JEP hay participación de las víctimas, la cual se va incrementando. Es así como hemos consultado a más de 60 organizaciones a nivel nacional y territorial en el campo particular de la violencia de género y la violencia sexual. Y de allí hemos estado diseñando mecanismos de restauración para este tipo de víctimas, justamente lo que están demandando las organizaciones, y estamos en ese proceso. Finalmente, hemos creado con el Gobierno Nacional, entre la Alta Corte, que es parte del sistema judicial colombiano, y el Gobierno Nacional, lo que hemos llamado el sistema restaurativo, que es una relación entre la autoridad judicial y las entidades del gobierno para crear los proyectos de sanciones que se aplican cuando los perpetradores han reconocido su responsabilidad y han hecho aportes a la verdad. Dentro de esos proyectos tenemos una línea especializada en daños diferenciales y de victimización macro. Quisiera mencionar, dentro de las 7 líneas que hemos diseñado, una que está enfocada en la restauración de daños de víctimas de violencia sexual y otras violencias basadas en género, y otra sublínea sobre víctimas, niños, niñas y adolescentes. Quisiéramos enfatizar que la contribución de la jurisdicción a la reparación no es una consecuencia o una relación simplemente directa entre el daño y la indemnización. La JEP se concentra en contenidos reparatorios que son complementarios de la intervención de las otras entidades del Estado. Muchas gracias.
Thank you very much, both representatives of civil society as well as representatives of the state. And so now I turn to the country rapporteur, Commissioner Caballero, for any questions he may have or comments.
Gracias, Presidenta. Un gusto estar aquí.
Thank you very much, Madam President. Greetings, Commissioner Pochak and Assistant Executive Secretary for monitoring and for petitions and cases. And enjoy seeing this table of women representatives of civil society and the members of the delegation of the state. Thank you very much for this hearty dose of information you provided for us, which is absolutely fundamental to learn about reparation for victims of the armed conflict in Colombia and inter-American system, and also for giving us background about the peace accords and what's going on in that regard there. And there's just one issue that I wanted to bring up that was mentioned recently with regard to the special jurisdiction for peace, that the reparative or restorative aspect is complementary to the rest of what the state is doing. I want to know whether the other agencies of the state have the same perspective. It's very important to hear this. It's all the lessons learned that can be built up with regard in terms of human rights, sexual violence, reproductive violence, crimes based on different prejudices. Has there been a unifying or a standardization of all the different agencies and how efforts for reparation are being put together with regard to these guidelines? That has been raised by civil society. That's really important. And the second thing is it's important with regard to the statute of limitations. if I'm correct in saying this, that it's based that the victims, from the moment when the victims learn about it, about the crimes. And so what are the means? How can this be established? And wouldn't there be other considerations to take into account for this, in addition to making this, bringing this in line with international conventions, etc., with regard to crimes against humanity and war crimes? But I want to this statute of limitations provision, does it take into account this differentiated gender-based approach and prejudice-based violence? In other words, it would seem that this view is along the lines of not acting. Can you provide an explanation in that regard? Thank you very much.
Muchas gracias.
Thank you very much. Greetings to the civil society representatives, and I salute you for requesting this hearing, and to the state's representatives. We know about the huge effort made by the government of Colombia to bring about total peace, and is unyielding armed groups and the boycott of different political sectors in Colombia, and so therefore we held a commitment to democracy and reparation for victims and restorative justice, etc., and all the different.
Son una muestra de ese compromiso y lo celebramos. A lo largo de los años, Colombia ha desarrollado un caudal muy importante de medidas de reparación por canales administrativos y judiciales frente a las graves violaciones de derechos humanos durante el conflicto armado. Sabemos los esfuerzos que se están realizando en los últimos años para enfrentar las deudas pendientes en materia de memoria, verdad, justicia y reparación. 1,5 millones de víctimas, acaban de decir, que fueron reparadas y que son apenas el 20%, es elocuente. En este contexto hemos escuchado hoy con preocupación que existen regresiones, y por eso estamos preocupados y preocupadas, que existen regresiones para el acceso a una reparación integral. A nivel judicial se ha establecido un plazo muy corto de caducidad para el acceso a las reparaciones económicas, que impone una carga desmedida a las víctimas y que tiene efectos desproporcionados en el caso de víctimas de violencia sexual. ¿Cuál es el motivo? ¿Cuál es el motivo de este plazo de caducidad que es abiertamente contrario a los estándares internacionales en materia de reparación a víctimas de graves violaciones de derechos humanos? ¿Cómo se justificó jurisprudencialmente este cambio? ¿Existen decisiones en otras instancias judiciales que mantienen el criterio amplio? No se pueden establecer condiciones en materia de reparación civil a víctimas de graves violaciones de derechos humanos. Ni 2 años, ni 5 años, ni demostrar esto. Es imprescriptible. Las acciones civiles son imprescriptibles, lo dijo la Corte Interamericana. Por otra parte, sobre el acceso a las reparaciones en sede administrativa, me interesa conocer si hay instancias de diálogo, porque realmente este proyecto de ley que están presentando, que presentaron en octubre y que parece muy auspicioso para superar algunos obstáculos que se han presentado acá, contó con participación de la sociedad civil en la elaboración. Pregunto a las solicitantes si han podido ver ese proyecto y si consideran que ese proyecto respondería a las preocupaciones aquí planteadas, y con mucho gusto desde la Comisión Interamericana y desde la Relatoría de Memoria, Verdad y Justicia en particular acompañaríamos entonces ese proyecto si logra superar todos los problemas que aquí se están estableciendo. Dejo acá por un tema de tiempo, pero estoy segura que la próxima visita a Iloco, que está planificada para el mes de abril, va a ser muy importante para fortalecer esta cooperación entre la Comisión Interamericana y el Estado, para continuar el diálogo con las organizaciones y bueno, trabajaremos juntos en esa agenda integral. Muchas gracias.
Muchas gracias, comisionado Pochak. Sí. Muchas gracias nuevamente, agradezco mucho las presentaciones. Quisiera reconocer de lo que todos están hablando, de la escala, de los desafíos para abordar todas las lesiones, de los daños y prejuicios. El 14% de la población fue afectada. Y se trata de 9 millones de personas. Es un gran desafío y hay que abordarlo en forma metódica. Igualmente, hay que reconocer que el embajador, el compromiso del Estado para dar reparaciones sustantivas y que no sea en vano, que no sea solo un saludo a la bandera. Entonces, eso se lo agradecemos. Quiero pedir al comisionado Guerrero y Pochak me uno a ellos en cuestionar esto de la caducidad. Entiendo que es un problema muy importante en la Secretaría.
Reparation, and that 2 years counts from the moment in which the interested parties become aware that the damage is imputable to the state. I believe that's the law. So my questions are two. What is the reason for this limitation? Why did this limitation come about, and in the time that it came about, what's the rationale for it? And secondly, in relation to harms imputable or damage imputable to the state, are we talking about harms perpetrated actively by the state, so acts of commission, or are we also talking about acts of omission, where the state fails to protect, where the state fails to prevent, where the state fails to investigate? How do we define damage and harm in this context here? And then, thirdly, I wanted to ask, what is the average length of time for resolution of claims for reparations so far? And then for the representative civil society, you spoke about youth, let me get exactly right, about children under 18 who were involved in perpetration but also demobilized before, at the age under 18. And I want to ask a little bit more about the significance of that. Are you suggesting that they be treated as child victims? And if that is the case, can you describe you talked about other solutions. What other solutions are you referring to that would be appropriate to child victims who also were put in harm's way as perpetrators? Thank you very much.
Thank you very much.
Maria Claudia Pulido.
Gracias, señora presidenta. Y luego de
Thank you very much, President. I'd like to greet the representatives of civil society and the distinguished representatives of the state. Obviously, the questions of the Commission were extremely relevant and on target, but I just want to raise some elements discussed by the organizations with regard to the concept of victim and the three different notions that were raised or discussed. And I want to ask whether you consider that the new proposal that it's in the legislative bill, whether these deficiencies have been overcome. These deficiencies that you see now, these shortcomings that you're decrying now, has this concept of victim been hashed out properly in the new draft legislation? Also, another thing has to do with the aspect raised by all the commissioners, and that is with regard to the prescription, the statute of limitations, that is. And when the person learns about the damage, how do you understand coming to the attention, learning of it, becoming aware of it? Is it through, how do you decide, how can you prove the very moment that they become aware of knowledge of it so that this statute of limitations, the time period runs from that point on? And so I'd like to understand from the state the direct relationship there are between the damage and reparation, and do you view it as a complementarity of the other mechanisms of reparation? How do you define
¿En qué consiste?
This complementarity? What does it consist of? What does it involve?
Sus representantes
And whether the representatives of the victims take part in this definition. That would be everything, President. Thank you very much.
Deputy Executive Secretary. So now we have the response, comments from civil society for 12 minutes, and the clock will be reset. And similarly, response from the state, 12 minutes. Please proceed, representative of civil society.
Good morning, members of the Commission. I'm Moreno. I'm a legal advisor of the Orlando Porta Collective. I'm going to talk about the statute of limitations. As has been mentioned by the representatives of the state, the prior period was from the point when you learn about the crimes, but direct reparation before the Administrative Claims Court decided this, it was complex to gain access to the administration of justice in the broad context, but now there has been an evolution with regard to the reparation that victims get. The term, it's counted from when the victims learn about the act. The difficulty is when they learn about it, based on the justice operators, and whether there's evidence, whether the state is responsible, or whether they can bring any suit in the administrative court. It was the Council of State that issued this ruling, of course, so they can. So as a matter of fact, the claims before 2020, but prior to the unifying judgment, led to retroactive claims prior to the unification criteria. And this applies even in cases where only after many years the family learns of the disappearance, and they learn actually about the circumstances in which the violation took place. And therefore, it's when there's certainty or any indicia that the state was responsible for causing the harm or violating the rights, or for extrajudicial execution, as the Commission or the international standard, the minimum standard is being violated, where there should not be any statute of limitations, or it should not be time barred when it comes to crimes, human rights violations, and crimes against humanity, more crimes, and justice operators should take into deal with this on a case-by-case basis in this armed conflict context. It's clear the difficulties of this conflict. And based on the figures that the Office of the Attorney General has issued through the working group as far as exhumation and handing over the remains of the disappeared person, there's not enough resources available for the proper investigation to be able to conduct all this, because they're not viewed as victims of outlawed groups. And also because of the statute of limitations, there has to be evidence, effective evidence. They have to get to be able to gain access to justice, and there's no legal certainty. And there's been the trial courts have issued decisions, and so that's pretty much all I can say now. And I'll give the floor to my colleagues. Thank you, Catherine Juradimas. I'm part of the Sismo Mujer JP's. First thing I want to say is we don't see the government. We appreciate its efforts, but we don't see any political will. And we're waiting for the materialization of standards with a gender-based approach. The percentage that they've referred to isn't even 2%. It's 1.6% of the women violence of sexual crimes, and they have not been compensated. And incorporated a gender-based approach, this has been weakened because with regard to the victims unit, assistance unit, with regard to the differentiated perspective on violence, sexual violence, gender-based violence, there hasn't been, it's not enough for reproductive violence to be mentioned. It's necessary to also talk about affirmation agents to investigate all types of this violence. If otherwise, it's going to be subsumed or it's going to be rendered invisible by the other types of violence. And so, among the ranks, the people that are recruited, and there's older and older people have to be considered victims as well. The unification judgment overturned the unconstitutional sentence, but it could take a long time, or it may not happen. But this government, in this window of opportunity, must take other measures to overcome this issue. And with regard to the law of victims, with regard to the processing of the reform, there's channels of participation that have been established, but we fear that it may take a long time, and in any case, there are no urgent measures to be taken to deal with a delay with regard to reparation, and therefore it's necessary because the former combatants and victims of gender-based violence, other measures have to be taken for them. I'd like to bring up three aspects related to the first one: the importance of coordinating between all the agencies that have to do with reparation, particularly the CHEF and Guardi, but not only that. No, we not only have backlog with regard to economic reparation, but also with restitution. Women measures. Women are still victims of violence in the process of restitution of land, and sexual violence victims, mainly rehabilitation measures which meet the standards. Women continue to die because they don't have access to comprehensive health care as a result of the victimizing crimes in the armed conflict. And then systematically, all the actors continue to deny that sexual violence took place. And so there's no guarantees of non-repetition. And the budget is important, but we have no sources to enable us to identify that how much are sensitive, and how many women victims of the armed conflict are going to come forward. And so this is recognized constitutionally as, and in two different orders that recognize the risks that are confronted by women in the context of the armed conflict. And lastly, I'd like to mention or ask, how long must women wait who are in this precarious situation, or who die waiting for a response, or waiting to overcome these legal or technical failures? With regard to implementation of the TORs, we'd like to say that the victims in building the peace accord, the victims actively take part in the implementation. However, these parameters have been affected by the passage of time. The representatives have said that there's no guidelines to establish how to build and implement these programs. With victims at the minute in implementation and design and at all stages, the beneficiaries have been once again harmed, the victims, as has been mentioned by the representatives of the states. It was with these ladies that was the decision, their effective and active participation in all of these, in this transitional process, beyond just identification or just listening to them. Civil society has experienced files where there has been important progress in building reparation measures for victims, because they know when, how, and under what circumstances they would feel that they've received reparation and their rights restored. So there's so many different intersectional factors that have to be taken into account. The responses for restoration and reparation for women have not been taken into account by the special jurisdiction for peace. Even though the DEP has opened up spaces in which victims have once again taken part, but the effective participation is not reflected when the measures that have been taken are not related to the seriousness, as not in proportion with the harm that's caused. However, we believe that there's minimums that are not being respected, and there's no formality, and this has an impact on the decisions that thus far have been taken. This has been reflected in the decision that have been taken, as we mentioned earlier. It's not proportional to grant a benefit to a perpetrator who has committed a murder. has put an end to the lives of so many people. That JEP has said between 2012 and 2002 and 2012, there were thousands of victims, and it wasn't clear the criteria for restorative justice for a period of 6 months when this is the most serious crimes that these perpetrators commit. So the main obstacles is the lack of coordination with civil society. This persists, and the budget is the other major challenge. But there has to be other sources of financing. Through the peace accords, the national government committed to draft and discuss and implement the accords, whose purpose should be establishing public policies for it to be implemented in this special jurisdiction for peace. And the JEP has also established different options to apply the TWAR. And so it was not shared, or the victims in civil society were not shared. This was not shared with them. These options are focused mostly on the general budget of and the general system of participation and of royalties and resources of the different territories and private sector resources. But there's a possible and feasible option, which is coordination, minimally. And different institutions with the jurisdiction should be involved. And this goes beyond providing compensation, even when this is important to provide for the basic needs of the families of the victims. Thank you.
Thank you. Quisiera preguntar todavía.
I would like to ask, do we have any more time? Oh, no, it's lapsed. Okay, no, the time is.
Yes, our time was like
Okay, so we did not use all of our time. Representatives of the state and civil society, we have 8 minutes to give away, and we're suggesting 4 minutes and 4 minutes additional. So you have 16 minutes and 16 minutes. So 4 more minutes? Yes.
Gracias. Sí, es que.
Thank you very much. So we would like to clarify something with regard to the statute of limitations. The Council of State moved away in Órdenes Guerra versus Chile. It's legal precedent, and it's an inter-American standard, and it departed from that standard. And the justification was domestic laws, claiming that the Colombian system works differently from the way the Inter-American Court has interpreted this period of statute of limitations for crimes against humanity. And this is banned by international human law, where it's been clearly established that the obligation of the state is to bring in line its domestic law with the spirit of international standards, and it should not be justified by the standards of domestic law. It has to be brought in line with international standards. I just wanted to explain the reason why there's been a departure in the judgment of unification judgment.
Now we turn over to the state.
Muy bien, muchas gracias. Yo quisiera comenzar haciendo referencia al tamaño del desafío de reparación que hay en Colombia, que ustedes han puesto de presente y las organizaciones también. Una de las contribuciones de la jurisdicción en términos de verdad ha sido mostrar que en Colombia no solo hubo un conflicto con móviles políticos entre unos grupos subversivos frente al Estado, sino que hubo una connotación de discriminación de género en los móviles de la guerra, y que la guerra se ensañó de una manera desproporcionada contra las mujeres, al igual que contra grupos indígenas afrocolombianos y contra los niños. Y esta es una descripción distinta del conflicto armado. Ahora, respecto a la reparación integral, es un criterio fundamental en la respuesta del Estado colombiano, que lo que ha hecho es dividir de acuerdo a los renglones o los componentes de esa reparación integral en diferentes instituciones. La restitución de tierras a través de un sistema administrativo y judicial particular, los temas de indemnización en la unidad de víctimas, indemnización administrativa y la indemnización judicial a través del contencioso. Y esto me permite a mí insistir en que la jurisdicción está a cargo de componentes que no tienen que ver con la indemnización. Y eso nos hace concentrarnos en temas de aportes a la verdad, que es lo que las víctimas han demandado en los procesos de participación, aportes a la verdad, el reconocimiento de las víctimas y las garantías de no repetición. Es en ese contexto en que se entiende el carácter de los trabajos y obras de contenido restaurativo. No es una reparación que responda a una tasación del daño y medidas de indemnización de ese mismo daño, sino respuestas mucho más generales que permiten garantizar, reitero, el reconocimiento de las víctimas, la reconciliación del país y en el medio del proceso de paz y las condiciones de satisfacción en cuanto a la no repetición. Por eso, es a lo que se debe que, por ejemplo, como lo referían las organizaciones, el proyecto, y es un buen ejemplo de lo que está pasando, los primeros proyectos de trabajos y obras de contenido reparatorio, el primero es educación en el riesgo de minas y desminado de minas antipersonal, y por el otro lado, la restauración ambiental. Esos proyectos no responden a una tasación específica o a un daño particular de las víctimas, sino que responden a una construcción general de restauración, garantías de no repetición, que sin duda tiene un aporte a la construcción de esa reconciliación en el país.
Gracias a la comisión por sus preguntas y a las representantes también de la sociedad civil por sus comentarios. Voy a referirme a un aspecto que ambos han tocado, y es el tema de las decisiones de nuestros jueces internos, altas cortes, sobre la caducidad en las acciones de reparación directa. Lo primero que quiero decir es que en el marco del respeto a la autonomía judicial, pues no corresponde a esta representación del Estado juzgar si esas decisiones están acordes con la Convención Americana o no lo están. Eso corresponderá pues a las instancias judiciales internas e internacionales hacerlo, dado el caso. Para explicar un poco más sobre los precedentes actuales y las decisiones actuales, en efecto, el Consejo de Estado y la Corte Constitucional, que son altas cortes en Colombia, han considerado esta tensión que existe entre el derecho de las víctimas de graves violaciones de derechos humanos a la reparación y, por otro lado, un principio, digamos, de seguridad jurídica que demanda que los conflictos deban tener de alguna manera un cierre y no queden perpetuamente abiertos a una resolución. En esa tensión, las Cortes han determinado que un balance adecuado a su juicio es no aplicar el término de la caducidad de 2 años que normalmente se aplica a las demandas contra el Estado, sino decir que esos 2 años se cuentan a partir, como lo reitero, de que la persona, la víctima, tiene conocimiento de que el Estado ha estado implicado por acción u omisión, o que materialmente, digamos, haya podido acudir a la justicia y no lo haya hecho. Es decir, es algo que se determina caso a caso, valorando la evidencia disponible y el material probatorio, que en efecto la carga de la prueba está a cargo pues de quien demanda, ¿no? Eso es lo que nuestros jueces en Colombia han determinado como un adecuado balance entre la atención de esos 2 principios. Ahora bien, el Estado no niega que esta jurisprudencia puede representar obstáculos de acceso a la justicia para algunas víctimas, especialmente víctimas de violencia sexual, y por eso ofrece, como es su posibilidad en el marco del proceso de reformas a la justicia que se está llevando a cabo, que las organizaciones solicitantes y otras que tengan esta preocupación, con acompañamiento de la comisión, si fuera posible, pudiéramos plantear reformas específicas que permitieran aclarar y considerar las barreras, especialmente en los casos que mencioné. Muchísimas gracias.
Muchísimas gracias a las organizaciones y a los comisionados. Lo primero es decir que el registro único de víctimas sigue aumentando porque mientras el conflicto en Colombia no se resuelva, pues la verdadera garantía de la no repetición del conflicto es la solución a la guerra. En tal sentido, la ley 1448, cuando nació en el 2011, se proyectó para 3 millones de víctimas. Hoy tenemos más de 9 millones de víctimas. Y este gobierno, pues cuando llegó también, ya está sobredocumentado por los órganos de control que se requeriría 301 billones, o sea, mal contado, sin todo lo que hemos recibido y lo que vamos a recibir en el registro único de víctimas, es decir, eso es cerca del presupuesto nacional de 4 años, en un país donde hay más territorio que Estado, donde no ha llegado las instituciones, digamos, ni universidades, ni colegios, ni escuelas. En este gobierno estamos buscando que llegue el Estado para que le pueda llegar a todos los territorios, pero eso es un dilema que es un asunto de la reparación que este gobierno está comprometido en llevarlo a la discusión central. El acuerdo de paz estableció, como la política de víctimas es anterior a la política de paz, que se debe reglamentar y que se debe discutir en el Congreso una política de víctimas acorde a la mirada planteada en el acuerdo de paz en el punto 5º. Por eso hemos radicado ese proyecto, porque digamos, en la discusión alrededor de la reparación y la centralidad de las víctimas hay que revisar cuáles son esas fuentes de financiación para más de 9 millones de víctimas y con el foco de los territorios priorizados para la paz. La fuente de financiación es realmente la solución real y eficiente.
Now, we hope very much that the 9 million victims will indeed be satisfied. This has to go through the Congress. We have a working table, a negotiating table, together with a broader context of the peace treaty, to try to set forth what the gender policy should be. But we have also adopted matters that have to do with an institutional nature, and particularly soliciting the contribution of the victims. There's a special law for victims. There are special articles of control. We have received 1.5 million different submissions. We try to negotiate a new draft bill with the government, and this will be subject to 7 different public debates that will be open to civil society. This, by means of democracy, will have to go to the Congress, subsequent to which it has to go to the indigenous peoples in those territories, has to satisfy the law there. Thank you. Well, we have sought as best we could, as you can see, to abide by the time made available here. Now, I think it goes without saying, and the representatives of the victims will agree, that it matters that all of them are women. And I think this tells us where the brunt of the armed conflict that we suffered in Colombia was most felt. Women bore the brunt. Everybody suffered, but nobody suffered more than the women. That is for sure. And if we consider the width and breadth of the commitments that our President Gustavo Petro has assumed and embraced within the ambit of the senses of human rights, we need to understand that this has been no simple thing. The Congress is constantly making life more difficult for the government. There's regressivity, there is toing and froing about judicial matters, as Mariana has just said. I'm sorry to say this is outside of our hands, certainly not fully in them. but we will have to be able to turn to what's left, which is the Inter-American system. There might be decisions that are contrary to the Inter-American system, but there is always a possibility of turning to the Inter-American system for further support. So the invitation that we are issuing here is that the different groups of victims get involved with the movement towards justice. We think that is necessary and the only way forward. And by the way, we would be deeply grateful for the Commission to help us in that regard. In what way? Well, when you go to Colombia in loco, the in loco visit in April, please, please, please come with specific recommendations to the government. Because it'll go to the government, but it'll also go, your recommendations, to the Congress, so that all of the elements of state, the state with a capital S, understand what needs to be recognized and built upon for justice to be rendered. Because, as I said from the get-go, the victims in this process were focused on as the most important element of the peace agreements. And if the victims are the most important element in the peace agreements, it goes without saying, does it not, that the victims have to continue to be recognized to be really what matters most. And as you know, the Constitutional Court got us very much involved in the whole law on victims, and I know very much that the law for victims, 1488, and the peace agreements were what we dealt with every day. But the respect for the jurisprudence of the Inter-American Court and the Inter-American Commission of Human Rights was recognized to be important and truly worthy of respect by everybody. That's, I think, something that has to be recognized. And it grieves me that anybody would suggest anything different, because anything different would mean regression. And if there's one thing we cannot allow is regression. We have to base ourselves, we in Colombia, on the peace agreements. It's a constitutional reform, and we were members of the Constitutional Court. We ensured that that be the case. And there has to be respect therefrom. That goes to the very summit of the Colombian judiciary and jurisprudential system. So I hope that we can abide by that, and I deeply hope that the Commission can guide us in that regard. Please, please be a part of this, and that reforms should be put forward to facilitate this concept of justice, truth, and the guarantee of non-repetition. Thank you very much.
Thank you very much, representatives of the state, Ambassador Vargas, and representatives of civil society. I think this has been a very instructive hearing for us. We hear very, very clearly your calling, civil society is calling for victim-centered, victim-responsive, restorative and reparative justice, where victims are at the table where any of this is discussed and where any decisions are made. We hear the state saying we're committed to substantive justice and not hollow words. And we also understand that the civil society has asked the Commission to consider a number of recommendations, which we will. As Commissioner Caballero has said, we will be in Colombia. It's in April? In April, where we can follow up some of this. In the meanwhile, we did ask some questions that you all would not have had the time to respond to. And so please know that you can send us your response in writing within the next 30 days, and we will be actively looking forward to some of these responses. And with that, I bring the hearing to a close, and I thank you all very much.